So, there is a new immigration policy. If your immigration case is denied and you no longer have status in the United States, guess what? You'll be placed in deportation. This is a new policy memo that was issued last month, but now we are starting to see those deportations orders coming. In this video, I'll tell you who is impacted, which applications are subject to this new policy, and what you can do about it. Hello everybody, and welcome back to Immigration Channel. In this video, I'm going to talk to you about a new policy that is coming from USCIS. This policy was issued last month, but now we are seeing the Immigration Service actually acting on it. And this policy says something very simple. It says, if you apply for a change of status inside the United States and this application is denied, that means you no longer have status and they will issue order of deportation for this application. Now, I'm going to tell you which applications are impacted by this. This will be applicable to people changing from tourist visas, from work visas, from marriage applications to green cards, and in some citizenship cases. We're going to cover this memo in detail, so make sure you watch this video all the way until the end. So let's talk about this policy. This policy is an internal memorandum that was issued by USCIS in late February. And this memo says something very simple. It says, if you are filing for a change of status inside the United States and your application is going to be rejected, we will issue what is called a notice to appear. Notice to appear to court. That is the notice that starts the removal proceeding for every individual that is now in the United States without status. What is interesting about this memo is up until now, ICE and CBP, Customs and Border Patrol agents, are the ones that issue those notice to appear to court when they arrest individuals. But this memorandum expands the authority of USCIS, the Immigration Service, and they also can now issue the notice to appear to court for applications that are being denied by this agency. So how will immigration implement this new policy? The USCIS, the agency that approves cases like I-130s, I-45s, the same agency that reviews cases, will now have the authority to issue notice to appear to court. And the way they're going to do it is simple. Once they process an application and they decide that this application will be denied, it's not just going to follow with a regular denial notice. It now will also follow with the notice to appear to immigration court, initiate your removal proceedings. So essentially what happens when you receive a notice to appear to court, you will have to appear to court at a particular date, and that will be the beginning of your removal proceedings. You'll have a master hearing, an individual hearing, and eventually the judge will decide on your future in the United States. All this will be initiated by USCIS from now on. This is a major shift from the Biden administration. Under the Biden administration, USCIS was only able to issue notice to appear on very limited cases. Most likely cases like if your conditional green card was denied and you didn't do anything else and you stayed in the country, eventually you would get a notice to appear to court. And the same thing when the extension of the conditions of the EB-5 I-829 form was denied, you will also get a notice to appear. These are the limited cases under the Biden administration when somebody got a case denied. But under this new policy, we now see a larger expansion of classes of cases that could get the notice to appear from USCIS. So let's understand who will be impacted. Before I tell you who will be impacted, if you guys are here for the first time, please subscribe to our Immigration Channel. Click the notification bell so you don't miss any of our videos and our live events every single week. And also give us a big like so YouTube will be able to show this video to more people just like you. As always, if you need help with any immigration matters, if you're worried about the case getting denied or need support with any other case, send me a text 619-483-4549 or go to www.immigrationasap.com and one of our team members will contact you ASAP. And now let's get back to the video. So who will be impacted? Anybody who is applying for immigration benefits with USCIS, filing form I-539. So for example, if you're here as a tourist, changing status to a student visa, or let's say you're here as a student and now you're applying for a work visa and that application is denied and now you're left with no status, guess what? USCIS will now have the authority to issue notice to appear to court and you'll be able to go to court. Now, the reason why we're recording this video now, almost a month after this policy is out, is because now we are seeing those cases. We have talked to a person that applied for a change of status from a tourist visa, been in the United States for about 4 months, applied for a change of status to apply for a student visa, from a tourist visa to a student visa, that application was denied. And guess what? That person is now issued notice to appear from immigration. Now, that person applied for this before the memo was issued, but the decision came out after the memo was issued. And as a result, notice to appear was sent, and that person is now in deportation. And obviously, if ICE catches that person, they can also get sent to detention. So that is one instant example. Another person is somebody that filed for removal of conditions on form I-751, and that application was denied. They now issued notice to appear very quickly. Under the Biden administration, we've seen those cases take months. And in many cases, they're not even issued notice to appear, even though they had the authority to do so. But now, under this administration, if your green card, conditional green card is denied, you will be issued notice to appear and you will be placed in removal proceedings. Now, if you apply for application based on employment, form I-140, those applications are currently outside of this policy. So if you're doing this based on employment, your case is denied, you still have the option to refile your application and you'll still be okay. Now, let's talk about criminal issues. If you have any criminal issues in your past, whether you're applying to renew a visa or you're applying for your green card to remove conditions as well, criminal issues are now going to be a major factor in their decision whether to issue a notice to appear to court or not. So if you have any criminal convictions and your application is rejected, USCIS will refer your case to ICE and you will be placed in removal proceedings. Also, if you're filing for a green card application to adjust your status, and your application for a green card to adjust your status was denied, and the immigration determined that it was not a real marriage, it was a fraud, and they thought there was misrepresentation, that denial could lead you to deportation as well. Versus in the past, you could simply just refile that application. Now, under this new memo, you will be sent to removal proceedings. So let's understand again, this memo covers also previous applications that were also being issued NTAs under the Biden administration. For example, if your removal of conditions for your green card has been denied, you will be placed in removal proceedings, NTA will be issued. If the immigration found fraud in your case, so you applied for a green card, that case was denied because of fraud, you will be also sent to deportation by issuing a notice to appear to court by USCIS. Also, if you're applying for citizenship and the immigration find out that you have certain grounds for removability or deportability before you applied for that citizenship, which means that you're not eligible to apply, then you will also be placed for removal proceedings at the end of your citizenship interview if they deny your case. So again, be mindful before you apply for your citizenship application, make sure you talk to an attorney to make sure that you qualify and or your past criminal issues are not going to impact your application for citizenship. And also, if you're coming back from a long trip overseas and you're applying to renew your green card, in many cases, if they determine that your application for a green card has been abandoned, you spend too much time overseas, they can issue a notice to send you to court, NTA, and you'll have to defend your green card before an immigration judge. So what's happening next? As a result of this memo, USCIS now has the authority to issue notice to appear to court, deportation orders on a case-by-case basis. So you have to remember, if you're going to apply for a benefit with USCIS and you're not sure if that case will be approvable, you're risking deportation. So think twice before filing and speak with an immigration attorney to determine what are the chances of this case actually going through, because if it's not just a simple denial, you're now going to be placed in deportation removal proceedings. So before you file an application for change of status, make sure that you have enough time on your I-94 to get a decision, because if that case is denied, you're out of luck. Once again, very important notice on change of status from tourist to student or extensions of status for tourists. Those cases will also be referred to court if denied. Also, there's a lot of high scrutiny right now on adjustment of status cases based on marriage. If you're applying for a green card based on marriage and your case will be denied, there could be a probability that immigration will send you a notice to appear to court and you'll be placed in a removal. So be mindful of how you file your green card cases as well. And finally, if you have any criminal issues, do not file any immigration matters until you talk to an attorney. Sometimes you have to involve the criminal attorney as well to make sure that it is safe to file your applications. And you can see USCIS now has more power. They can issue notice to appear to court and send people to deportation. So be mindful, be careful, and be aware of this memo because I don't see too many people talking about it. And it's very important for you to be aware that this memo exists and you need to be careful when filing for change of status or any application inside the United States. Once again, thanks for watching. And as always, if you need help with your immigration matter, send me a text 619-483-4549 or go to www.immigrationasap.com and one of our team members will contact you ASAP. Thanks for watching, and I'll see you on our next video.